Wills versus trust. What is the difference? Which one's better? Which one do I really need? So first, let's start off by looking at what happens when someone dies. When someone dies, there's three scenarios you could be in. The first one is you do nothing. So by default, we have nothing going on, meaning we have no will, we have no trust, nothing set up. So when that happens, when we die, everything is in our personal name. And anything that's in our personal name when we die automatically gets frozen. And then what happens is it must go through a court process called probate. So probate is the process where your frozen assets, because you're no longer alive, your frozen assets are going from your frozen estate over to a beneficiary. That's just the person who's going to benefit and receive those assets. So there must be a court proceeding where a judge decides who's going to get what. Because you didn't set up a will, you have no trust, nobody knows who's going to get what. So a judge is going to decide based on, closest of kin or relationship or whatever they use to decide who's going to get which assets. Now, the reason people want to avoid probate is because one, it's lengthy. Probate can take years to complete. And two, it's expensive because you have court fees and then typically you have attorney fees. And I'm sure you know the longer you're in court, the more expensive the process can get. So people want to avoid probate at all costs. Now, there are some assets that avoid probate altogether because they have a beneficiary designation. Those are things like retirement accounts and life insurance, but you have to make sure you know and remember to actually put someone in the beneficiary designation. Sometimes if you leave it blank, then it goes to your estate and then you're back in the same probate process. Now, another reason people want to avoid probate is because it's public record, meaning I can actually go on Google, look up your probate process and see what assets are involved and who actually got what. So some people don't like the fact that people can go in and see like, oh, well, I have these certain assets and I don't want them to know that my niece now inherited XYZ. Scammers may target your family, but some people just want their things to be out of the public eye. So with probate, it is a public process, so anyone can know and have access to what happened during the probate process. So that's what happens if you have nothing going on, nothing set up. Now, the second scenario is you die with what's called a will. A will is just like a list of instructions saying who gets what. So I have all these assets and I write in my will, my niece is going to get that, my nephew's getting that, my son's getting that, my grandkids getting that. So now there's a list of assets and a list of beneficiaries assigned to them. So it seems like it would be helpful, which it can be looked at as helpful. The problem is that the assets are still in your name. So those assets still stay inside your personal name because a will doesn't take place until you actually die. So when you die, the assets are in your names, which means those assets are again going to be frozen and must go through probate court. So the same thing that I mentioned before, it's lengthy, it's expensive, and people want to avoid it at all costs. But when you have a will, you do not avoid probate. Now the difference is now the court has some type of guide they can use to determine, okay, they wanted so-and-so to get the house, they wanted this person to get the business. So it kind of can be looked at as helpful, but at the same time, it's still the same thing, same court fees. It's lengthy, so you still want to avoid probate, and it's still public. Even though you have a will, everything that goes on in probate is still public record. So that's the second scenario you could be in. So first is you die with nothing. Second is you die with a will. Now the third scenario is you die with a living trust. Now a living trust is a legal arrangement between three parties. Now party number one, the grantor, is assigning party number two, the trustee, the ability to manage assets for party number three, which is the beneficiary. So there's three parties. There's the grantor. The grantor is the person that sets up the trust. Then you have the trustee. The trustee is the person that manages the trust. And then you have the beneficiary. The beneficiary is the person that benefits from the assets in the trust. So three parties make up the trust: grantor, trustee, and beneficiary. Now, during your lifetime, in most cases when you're setting up a revocable trust, you're going to be all three parties. So you're going to be the grantor setting up the trust, you're going to be the trustee managing the assets of the trust, and you're going to be a beneficiary benefiting from the assets of the trust. So because you're all three parties, you maintain complete control over the trust. So what do I mean by complete control? That means you can make changes. You can change the beneficiary if you want. You can take assets out the trust. You can add assets to the trust. You can make changes whenever you want. So when you're operating day-to-day life, it's almost as if the trust does not exist. So the difference is you're not just going to sign your name for things. You'll be signing your name, trustee of XYZ Trust. So you'll be able to name the trust whatever you want to name the trust. and you'll be the trustee of that trust. So that's the main difference. So you're not losing control. You maintain control over the assets. You could take things out, you could put things back in. So that's really important to know when it comes to running and operating your living trust. Now, other than yourself being the grantor, trustee, and beneficiary, you're also going to set up successor trustees and successor beneficiaries. Successor trustees kick in if you become incapacitated or if you pass away. So in the case where you become incapacitated, meaning you can't make decisions for yourself, then the successor trustee kicks in and they can start making decisions for your benefit. And it's important to know that just because they're the successor trustee, they still have to make these decisions for the benefit of you because you're the beneficiary. So they just can't totally disregard you out the equation, meaning I'm just going to sell the home and sell that. No, they still have to prove that it's for your benefit. And then you have the successor beneficiaries. Those kick in upon your passing. So those are the people that will ultimately receive the assets when you pass away. So as a quick recap, you'll have the grantor, the trustee, and beneficiary who will all be you. And then you'll have the successor trustee and the successor beneficiary, and those will just be backing you up and being your replacement. Now, one of the most important parts of the trust, which sometimes gets overlooked, is not necessarily setting up the trust. Of course, you have to set up the trust, but other than actually setting up the trust, you have to fund the trust. So funding the trust actually means taking assets out of your personal name and putting them in the name of the trust. So one popular would be real estate. So with real estate, you're going to use the deed. So the deed typically has your name on it. So you're going to get the deed, change the deed from your name to the name of the trust. Not only that, you have to record it with your county. So once you record it, then the county will have it on record that the trust now owns that property. Now remember, you're managing the trust, you're controlling the trust, but now the trust owns the property. And then you want to do the same thing for other type of accounts. So if you have a bank account, you want to take your trust to the bank and either transfer your personal account to the name of the trust, or just simply take the trust to the bank and open up a separate account, and you can transfer the funds over to the new account that's owned by the trust. So you do that for your bank accounts, do that for real estate. You can change your life insurance beneficiary over to the trust. You can have your retirement accounts, because remember, those have a beneficiary designation. You can change that to the trust. So you can have everything funneled to the trust, and now you're just responsible for changing one beneficiary and assigning how you want these assets to be distributed to your family. Now, since you're actually taking these assets out of your personal name and putting them in the name of the trust, that means when you die, nothing is in your personal name. So that's how a trust avoids probate, because probate is the process of taking your assets that are frozen and giving them to the beneficiary, but your living trust is still alive, right? So even though you die, your living trust is still alive, and your living trust is the owner of those assets. So now those assets can be distributed to your beneficiaries, avoiding probate 100%. And also, because it avoids probate, that means it's a private transaction. So no one can go in and look up, any type of records to see what was inside your trust and who got what. It is completely private. And that's another amazing feature that people like about trust, is that nothing is on public record. So it's in the name of the trust. And then when you die, the trust is going to send your beneficiary the assets the way you chose. So you get to choose if someone's going to get everything outright, or if you want somebody to get a sprinkle of money at a certain age, a bigger sprinkle, and then give it all to them at another age. You control that 100%, and that's the beautiful part about the trust, because you design it exactly how you want it to be done, as if you were still alive. So I hope this video helped you understand the difference between having a will and actually having a trust. I personally always recommend using an attorney when setting up a living trust. So if you need help finding one, you can go to the description box, go to my website, and we'll help you get connected with an attorney in your local area. So if you have some other questions, put them in the comments below, and I'll make follow-up videos if necessary. Otherwise, put a thumbs up if this video was helpful, and I will see you in the next video.